For judgment, item number 1.
In view of the foregoing analysis and conclusion, this court is of the opinion that the learned trial court has not committed any error, either in fact or law, in convicting the appellant. So, appeal is dismissed. Thank you for the assistance.
Obliged, my lord.
For admission, item number 2.
This is for
Praise the Lordship.
yes.
Lordship, this is a Jimma petition. The vehicle which was detained by DRI authority from last almost 1 year, Your Lordship. And we have approached the learned lower court for releasing the vehicle. Learned lower court order is I annex with in page number, Your Lordship, page number 15 of my Jimma petition.
15.
15, yeah.
Yes.
And in page number 15,
What is
if
the
your
reason? Where is the reasoning given by the trial court?
Yes, Your Lordship, I will like to take Your Lordship kind attention in para 3 of the judgment and order, which is in page 16.
16.
Yeah. In para 3, Your Lordship,
Yes.
it is stated that Learned Standing Counsel for the respondent submitted that the case is under investigation and it is not yet known if the applicant has any involvement in the commission of the instant case. Hence, he prayed the court for not to reject the application for the interest of justice.
This must be a typing error.
That Your Lordship,
Yes.
Lordship, I like to say that. I know, Your Lordship, that is Your
Definitely.
Lordship may presume that it is technical mistake is there, but Your Lordship, I like to say
You
that.
read the whole sentence, no, as a whole.
Yes. Your Lordship, I like to mean that that the Learned Standing Counsel has informed the court that investigation is not yet completed, which is almost 1 year, Your Lordship. In which law there is he says that their investigation should be completed within 1 year or 2 year or 3 year. They have not taken even the time from the court also, and it is almost 1 year they have kept the vehicle under their custody. They have no their safe custody also, Your Honor, Lordship, because they have kept the vehicle in custom custody. That DRI has no any parking place for keeping the vehicles.
Show me the RC.
Yes, Your
Where's
Lordship.
the
I have
RC?
annexed the RC. I have annexed the RC, Your Lordship. Page number, Your Lordship, page number 10.
10.
Yes.
Nurul Haq, and you
Yes.
are Aminul Haq.
Yes, Lordship,
Then
I have
how do you
purchased
say
by
that-
I have purchased by using the sale deed, which is also annexed in page number 11, Your Lordship.
Right. Sale deed, anybody can manufacture a sale deed, no? the name in the RC is not yours. So how do you say that you are the owner?
Your Lordship, actually this is the authenticated documents, Your Lordship, of course. Your Lordship may say that anybody can, but Your Lordship, this is
The
notarized and
case diary is here.
I seek your Lordship indulgence.
Yes.
Your Lordship may take Lordship to the order dated 21/1/2025, passed by the Honorable Court, Lordship.
Okay, that is it.
That is, on that order, Lordship, this Honorable Court had passed an order saying that having the submissions made by the learned counsels, the learned counsel for the petitioner is allowed to file additional
Dated?
dated 21/1/2025.
Okay,
Lordship.
okay. Yes,
Second
yes,
paragraph,
Second
Lordship.
paragraph. Learned counsel
The
for
pet-
petitioner is
yes.
allowed to file an additional affidavit incorporating the necessary documents to prove his ownership. So has that been filed?
That was
Your
not filed.
Lordship,
And
Your Lordship, actually, that person concerned, he is hospitalized in Belur, so he cannot give me the proper documents. So I cannot submit
unless this
the-
order is not complied, Your Lordship,
Yes.
that submission.
Obviously, the court was not satisfied
Yes,
with your
Lordship, yes.
documents, so the court told you to file additional affidavit, but you have not filed.
Lordship,
Lordship,
yes.
may be given some more time so that I can comply.
Lordship, the reason why we have
We
objected
will
was
dismiss
that,
this petition because,
Yes.
and what does the accused say? Who is the owner? What does the accused say? That is also important. No?
very true, Lordship.
Yeah. So has the accused said that you are the owner?
Yes, Your Lordship. It is stated that.
You're sure?
Because, yeah, because accused stated that, Your Lordship,
It's commercial quantity, isn't it?
Commercial
Yes,
quantity,
commercial
Lordship, yes.
quantity.
And Your Lordship, three names has been, came up during the course of investigation, Lordship. I have
You have
stated
filed
at
your
para number 8.
counter?
Yes, Your Lordship. Page
Para?
5, paragraph number 8, Your Lordship. Page 5, paragraph number 8.
Eight.
Page 5,
Yes,
paragraph number 8,
yes.
Lordship. With regards to paragraph number 6, the answering respondent submits that there is nothing wrong done by the respondent since the seized truck was used for concealment and transportation of the huge quantity of illegal substances in the instant case. Moreover, the actual owner of the vehicle is not able to ascertain till date since the name of three persons came up during the time of investigation whose name are Anurul Haq, registered owner, Makbul Hussain Laskar of Badagar, Silchar, mentioned as the owner of the vehicle by the accused, driver of the accused, and the instant applicant. Hence, there is a clear disputed question of fact regarding the owner of the seized vehicle, and therefore it is necessary to adduce evidence to ascertain the owner of the vehicle. Further, the said vehicle was kept in the safe custody of the Customs Division Godown, Aizawl, via letter such and such, and as such, there is no chance of damaging the said vehicle at this stage, and as such, the instant application is liable to be rejected, Your Lordship. And I have annexed the registration certificate, which is at page 7, Annexure 1. Annexure 2 is vehicle particulars. So here in that vehicular particulars and registration certificate, name of the owner of the vehicle was Nurul Haq. But the statement of the accused is annexed at page number 9, Annexure 3. So he had mentioned the other name. Lordship.
Acha, where is that?
Second paragraph, Lordship.
Second paragraph.
May I read, Lordship?
Yes.
I have been driving my present vehicle, truck bearing registration number such and such. This is the seized vehicle. Since the last 1 year, approximately, I normally transport grocery items to different parts of Mizoram from Silchar, Assam. My present visit to Churachandpur is my second time only. The present owner of the truck bearing registration number such and such is Makbul Hussain Laskar. This is the statement of the accused. And now another person who is the petitioner came up before the court saying that I'm the owner. So it's not certain. So at this stage, it may be very dangerous to release the seized
Petitioner
vehicle.
is one, then
Yes.
this Makbul
Your Lordship.
Yes.
Laskar is one.
Yes,
Then
and the
there's
present.
another name in the
Yes,
RC.
that's why this Honorable Court had stated that the petitioner is allowed to file additional affidavit incorporating the necessary documents to prove his ownership. So that was failed to do so by my learned friend Lordship.
Your Lordship,
Yes, please.
Your Lordship,
Yes.
learned, my friend has not fully read out the second para. What is written in the second para? He is the same second para, Your Lordship, why he has stopped. Let me continue. He is the manager of my vehicle. That Makbul Hussain is the manager of the vehicle. He is not the owner, Your Lordship. That is stated by the driver itself in the statement. And then my learned friend is giving wrong information that Makbul Hussain is the owner.
No, but still, your identity and your ownership is not established. Yes. Okay, I am disposing, okay, right. Item 2. Heard learned counsel for the petitioner, Shri N.H. Barbuya.
Yes, H. Borbuya.
H.
It
Borbuya.
should be A, Your Lordship.
Oh,
It's
Barbuya.
wrongly written N.
Yes. Okay. This is an application under section 528/529 of the BNSS 2023 for releasing the seized vehicle bearing registration number AS 11-DC-4048 under bracket truck seized on 23/4/2024 in connection with DRI seizure case number 02/C1/IMP/METH/DRI-AZL/24 under section 8 under bracket C small c of NDNPS Act by the DRI Regional Unit Aizawl. Stop. The learned counsel for the petitioner is aggrieved by the order of the learned Special Court NDPS Act Aizawl, Mizoram, dated 4/10/2024, by which his application filed for release of the aforementioned seized truck was rejected by the learned trial court, basing on the submission of the respondents that the case is under investigation and it is not yet known if the applicant has any involvement in the commission of the instant case. Stop. The learned trial court has come to a finding that the investigation into the case is not yet concluded and the involvement of the petitioner is yet to be established. Accordingly, the petition was dismissed. Stop. Learned counsel for the petitioner has come before this court assailing the said order of the learned NDPS court, stating that he is the owner of the seized truck bearing registration such and such, okay, the one which you have stated. And he has produced a copy of the sale deed executed between the registered owner of the vehicle and himself dated 29th June 2023. Stop. He has stated that even though his name is not reflected in the RC of the seized vehicle, he has already bought the vehicle from the registered owner on 29th June 2023, and accordingly he is the lawful owner of the seized vehicle. Stop. The petitioner also submits that he had no knowledge about the contraband substance which was recovered from the seized vehicle, and accordingly he is the innocent owner of the said vehicle. Stop. Learned Counsel therefore prays that the seized vehicle, the aforementioned seized vehicle, may be released on Zimma to the present applicant pending conclusion of the trial, as the vehicle will be subject to decay and damage if kept in the open for a long time. Stop. Learned Counsel Sri Johnny,
Yes, Lordship, yes.
Johnny appearing for the DRI, has also filed his affidavit in opposition, and at paragraph 8 of the affidavit it is stated that the actual owner of the vehicle is yet to be ascertained till today, since the name of 3 persons have come up during the investigation, number 1, Nurul Haq, N-U-R-U-L, Haq, H-A-Q-U-E. Nurul Haq, the registered owner, Maqbul, M-A-K-B-U-L, Maqbul Hussain Laskar of Bagadar, B-A-G-H-A-D-H-A-R, Bagadar Silchar, mentioned as owner of the vehicle by the accused/driver, and number 3, the instant applicant. Stop. Hence, there is a clear dispute regarding the ownership of the seized vehicle, and therefore this court may not allow the present petition at this stage. Stop. The Learned Counsel has also drawn the attention of this court to the statement of the accused made during the investigation, which is at Annexure 3 to the affidavit in opposition, wherein the accused has clearly stated that the owner of the truck bearing registration number AS-11DC-4048 is Maqbul Hussain Laskar, and he is from Bagadar Silchar. Stop.
Lordship, one more submission.
Yes.
May take Lordship to my affidavit in opposition, page number 3, paragraph number 4. Paragraph number 4,
Yes.
the last sentence, Lordship. This is regarding the sale deed. Presuming but not admitting that if the said vehicle is purchased by the applicant from the registered owner, the applicant shall transfer ownership in his name within 14 days from the date of execution of the alleged sale deed dated 29/06/2023. However, the same was not done till date, till it was seized by the answering respondent, which is a clear violation of mandatory provision of Section 50 of the MV Act 1988. Hence, this application is devoid of merit. Your Lordship, as per Section 50 of the MV
Yes,
Act,
yes,
it is
has
very
to be
clear. Yes.
It has to be transferred. Yes. Learned counsel for the DRI, Sri Johnny, has also stated at paragraph 4 in the affidavit in opposition that even presuming but not admitting that the said vehicle was purchased by the applicant from the registered owner, he should have transferred the ownership into his name within 14 days from the execution of the alleged sale deed dated 29/6/2023 as per the provisions of Section 50 of the MV Act 1988, However, the same has not been done till date. Stop. Learned counsel has also referred to the order of this court dated 21/1/2025, wherein the petitioner was allowed to file an additional affidavit incorporating the necessary documents to prove his ownership of the said vehicle. Stop. Even the additional affidavit has not been filed till today. Stop. Accordingly, learned counsel prays that the present petition may be dismissed.
Yes.
Stop. Next paragraph. The court has considered the submissions of the learned counsels for the parties and perused the necessary documents enclosed along with the petition as well as in the affidavit in opposition. Stop. This court is of the view that the petitioner has not been able to prove his ownership of the seized vehicle as the registration certificate does not reflect his name, comma. Moreover, the deed of sale which has been made on 29th June 2023 is a doubtful document as the petitioner has not been able to transfer his name in the registration certificate as mandated by Section 50 of the MV Act 1988. Moreover, the accused / driver has not named the present petitioner as the owner of the seized vehicle. Stop. In such circumstances, when the ownership of the vehicle cannot be ascertained, comma, this court is not inclined to allow the petition. Stop. The statements made in the affidavit in opposition of the DRI has also not been replied to or rebutted by the petitioner in any way, and he is also unable to file the additional affidavit as directed by this court on 21/1/2025. Stop. Accordingly, this application is this petition is dismissed as having no merit, and the impugned order of the learned trial court is not interfered with. Petition disposed.
Also black.
Yes.
Item number 3.
I please your lordship. My lord, steps was taken upon respondent number 2, 3, and 4
Yes.
in compliance with order dated 6/2/2025. However, according to the office note, my lord, ID card has not returned.
Yes, it is not returned.
Yes, my lord.
So it is now, you
Uh,
took steps on 23. Wait. No, no,
Lordship-
this is a noting of 23. So today is, it's not even 1 week.
Yes, my
So
lord.
should we wait?
Yes, my lord.
Lordship,
It may be
yes.
waited.
I just received an instructions
Oh,
to
okay.
appear on behalf of respondent number 4.
4.
Yes, my lord.
Okay. Learned counsel for the petitioner is present and has stated that as per the office note dated 23/2025, the notice has not been served upon, notice served on respondent 2, 3 and 4 is yet to return. Stop. Today, learned counsel, MS
Baby
such as-
Laldin Zwali.
Baby, yeah, you write the name, okay? Appears for respondent number 4. You have filed your vakalat?
Not yet, my
Not
lord.
yet. And prays for some time to file her vakalat nama as well as the affidavit in opposition. Prayers allowed. List the matter after 3 weeks?
After 3 weeks, yes,
After 3 weeks. In the meantime, await service report on respondent number 2 and 3.
Obliged.
Item number 4.
May I please, Your Lordship?
Yes. Yes.
May I please? Lordship, this matter may be adjourned today, Lordship. I have some personal difficulties also, and some instruction is required from the appellant, and they wishes to engage the senior counsel also in this matter. So, if subject to Your Lordship consideration, I would like to get an accommodation on 5th of April, Lordship.
Okay. And have you served copies on the respondents? It says
No,
here
Lordship.
copy not yet served.
Not yet served, Lordship.
Not yet. You do that also.
Lordship.
Learned counsel for you are?
For the appellant, P.A.
No, no,
Chaudhary.
your name.
Tahir Ahmed Chaudhary.
Your name is not here, no, in the cost list?
Here,
Oh, Tahir
Lordship.
Ahmed, okay, okay.
Yes.
Heard learned counsel for the petitioner, for the appellant, Shri Tahir Ahmed Chowdhury, who prays for another date as he is, he has to get some instructions, further instructions from his
Yes.
clients, Yes. Accordingly, on the prayer of the appellant, list the matter on when?
5th of April, Lordship.
5th April is a Saturday.
Lordship, then is 6th.
6 is Sunday.
Lordship, sorry.
So let it be 4th April
4th April.
or
Let it be on
7th.
8th, then.
7th.
7, Lordship. 7 will be good.
This is the matter on 7th April. The appellant shall also take steps to serve the copy on the respondents as directed by this court on 19/3/25. This is the matter on 7th April. Yes.
Lordship.
For orders, item number 5.
Highly obliged.
May it please, Your Lordship.
Yes.
My Lord, this appeal is directed against the airship application number 11. I apologize. Yes, 1135 of 2020, which was issued via order dated 25/11/2020. Now, this airship application, Your Lordship, has been issued in respect of the property left behind by my mother, whereas the respondent herein is my niece, daughter of my brother, youngest brother.
Okay.
I was previously serving in the Indian Army, and I was away in service out of the state. And while I was posted outside of Mizoram, this airship certificate was applied by the respondent.
Without
Now-
notice to you.
Yes, that is our main grievance, Your Lordship. That opportunity may be afforded to me just to plead my case before the learned trial court before the decision is arrived.
Delay is also condoned, huh?
Delay already condoned, In fact, our main grievance is that Your Lordship may kindly turn to page 15 of my memo of appeal. Annexure
1.5.
1.5. The relevant page is at page 18, 1.8.
Yes.
Your Lordship at the bottom may notice the date mentioned in the affidavit is 25th of November 2020.
25/11/2020. Yes.
At the next page is the order granting the airship. 25, same day.
Same day.
So, our humble prayer before Your Lordship is that this airship certificate along with the order granting it may be set aside and the matter may be considered afresh by the learned trial court after giving due opportunity. That is our only prayer, Your Lordship.
It's,
Yes,
it's a limited prayer. Do you?
Yes, my lord, we have no objection regarding their prayer. That if the matter may be sent
Remanded
back,
back,
yeah, giving them opportunity of being heard for presentation of their version. So we have no objection.
Okay. Okay, please check. Heard learned counsel for
Appellant.
the appellant, Shri such and such. Heard also learned counsel for the respondent, sole respondent, no?
Yes, Your Lordship.
So
No, my lord.
representing the state government. Okay, okay. Okay.
Pro
For
forma.
just say, for respondent. Secretary Land Revenue, no? Learned counsel such and such for respondent number 1, and learned counsel, learned government advocate such and such for respondent number 2. Stop. This RFA has been filed under order, this is
Order 41.
41 Rule 1 and Section 151 of the CPC 1908, read with Section 17 of the Mizoram Civil Courts Act 2005, against the order dated 25/11/2020, passed by the Court of the Senior Civil Judge 3, Aizawl, in airship certificate application number 1135 of 2020, including airship certificate dated 25/11/2020, bearing memo number 511 capital SCJ under bracket A dash 3 Roman 3 slash 2020, issued to the respondent number 1 pursuant to the said order dated 25/11/2020. Stop. The limited prayer of the appellant in the present case is that the respondent number 1 herein had applied for an airship certificate in respect of the LSC number CAD-1496 of 2012, left behind by Srimati Lalrinthangi, Lalrinthangi, L, before the Court of Senior Civil Judge Aizawl, which was registered as airship certificate application number 1135 of 2020. The affidavit page of the airship certificate application, which is at, just take me to that,
Page 18, 1.8.
yes, which is at page 18 in the appeal memo, was submitted on 25/11/2020. Stop. Pursuant to the application, the airship certificate, the impugned airship certificate was issued to the respondent number 1 on the very same day, that is 25/11/2020, without issuing any notice to the present appellant, who is the daughter,
Son,
who is the son of the deceased,
Lalvin Thangi.
yeah, Srimati Lalrin Thangi. Stop. The appellant has therefore prayed that the matter may be remanded back to the learned court below, and that he may be given an opportunity of being heard and to submit his written objections to the heirship application. Stop. The learned counsels, next para, okay? The learned counsels appearing for the respondents have no objection to the prayer of the appellant in the present appeal memo. Stop. Accordingly, the appeal is allowed. The matter is remanded back to the court of the Senior Civil Judge 3, Aizawl. Stop. The learned trial court is directed to hear the matter afresh after giving an opportunity to the present appellant and after hearing both the parties. You need a date to appear before the court below. You can.
No, not particular date.
It's okay, no? Appeal is disposed.
Your Lordship, if I may,
Yeah.
it would be rather helpful if a date can be fixed.
Yeah, that's why date for appearance, no?
If it's possible, 1st of April, I think should give enough time for everyone. That's
1st of April.
slightly over a week from today. April is a Tuesday.
Acha, did I say to quash the, no? In between, you just say the order dated 25/11/2020 passed an heirship certificate application number 1135 of 2020 and heirship certificate dated 25/11/2020 is hereby quashed and set aside. Then after that you come, the matter is remanded back. Okay. Then last para, the parties shall appear before the learned trial court on 1st April 2024 or 2025.
Deeply obliged.
Highly obliged.
Item number 6.
Lordship, office note indicates that notice upon the respondents not completed, Lordship. So we may wait for some other time, Lordship.
The office note dated 23/2025 indicates that service report on respondents 1 to 3 has not returned till date. Stop. Accordingly, list the matter on. Should we give 2 weeks?
2 weeks, Lordship, yes.
List the matter after 2 weeks, awaiting the service report on respondent number 1 to 3.
Lordship, yes.
Item number 8.
Lordship, in the item number 8 also notice upon the respondents not completed. So same order may be passed. Lordship.
Same order,
Mhm.
awaiting service report on respondent 1 to 3
Lordship,
is the matter after 2 weeks.
Part 2 hearing. Item number 7.
MSc appeal. Ready? Parties are ready.
Yes, Your Lordship.
Yes.
May it please Your Lordship. Your Lordship, this is an appeal, insurance appeal, company appeal,
Yeah.
against the judgment and order dated 19/10/2023, passed by presiding officer MSCT Aizawl in MSCT case number 24 of 2021.
Yes.
Your Lordship, the facts of the case leading to filing of the instant appeal is that there was a vehicular accident between two vehicles, Scorpio and Chevrolet Spark, on 10/4/2021 at Chalkhan Kon, Sailam. And after the said accident, the respondent number 1 instituted a claim petition before the MSCT Aizawl, alleging that his vehicle, that is Chevrolet Spark, suffered severe damage due to the said accident that dated 10/4/2021. So in order to substantiate the said contention, the claimant submitted a police report dated 16/7/2021 and an accident inspection report of MVI, Aizawl District, along with the claim petition. In this regard, Your Lordship, I would like to bring your kind attention to the claim petition, which is at the LCR.
Yes, seriously.
The claim petition is at page number 1, and more particularly to police report and accident inspection report. The police report is at page 21.
Page 21.
21. Lordship.
Yes.
May I read, Your Lordship?
Yes, please.
Police report. This is to certify that on 10/4/2021 at around 1 p.m., one vehicle, Scorpio, bearing registration number MZ01P2457, driven by Lal Nun Chunga, son of Lal Sianga, late of Longklai, PA Ramhlun Bangthar Aizawl, proceeding towards Aizawl from Tenzol, was collided with one car, Chevrolet Spark, bearing registration number MZ01J8843, driven by Lal Ming Duoma, son of Arwal Kuma of Kohai, proceeding towards Kohai from Aizawl at Chalkhan Kon, Sailam. As a result, the said car, Chevrolet Spark, bearing registration number such and such, got badly damaged, and MVI requisition for mechanical inspection of the said vehicle has been sent to DTO Aizawl, and the report is enclosed herewith. So in this regard, this police report put reliance upon the inspection report, accident inspection report of the MVI Aizawl District. Your Lordship, the MVI report is at page 18 of the LCR.
18.
18.
Yes.
Your Lordship,
15 July.
18 July, yes, 15 July. And that is the letters sent by the MVI inspector to officer in charge of Sialsuk Police Station. That Sialsuk Police Station is the one who prepared the police report. And as per the said letter, that letter has a reference. That reference number is D/SLK PS /2021 /14.
DSLK-PS-2021-14. Yes.
And dated 9/7/2021. That date is relevant, Your Lordship.
dated
So-
9/7/2021. Okay.
That means the requisition was made on 9/7/2021. So perusal of the said police report indicate that the said report put reliance upon the report 15/7/2021 made by the MVI to establish any damage suffered by the vehicles. So in this regard, I would like to submit that the said MVI report cannot be accepted to indicate any damage suffered by the Chevrolet Spark due to the accident dated 10/4/2021. In fact, perusal of that letter dated 15/7/21 indicate that a requisition for inspection of the accident vehicle was sent to MVI only on 9/7/2021. So in this regard, I would like to bring the attention of this honorable court to the evidences adduced by both the claimant and the claimant witness number 2. Their evidence is at the claimant number 1. The claimant evidence is at page 62 of the LCR. 62 is the examination in chief.
Page 62. This is claimant 1.
Yes, claimant number 1, Sila Sangzula, examination in chief. And the cross-examination portion is at page 53.
53.
53, Your Lordship.
Okay.
Oh,
Cross.
53. And the cross-examination by OP number 2. Para number 6. Para number 6,
Yes,
may I
it's
read, Your
page
Lordship?
C5.
Para number 6, it is a fact that the OC, CLSU PS, made a requisition
No,
for accident
You're
inspection
referring
report.
to page 53, isn't it?
The cross-examination part is
Okay,
starting
okay.
from at
Page-
page 53.
Yeah, but you're reading from page 55.
Yes,
Yes.
para number 6. It is a fact that the OC, CLSU PS, made a requisition for accident inspection report of vehicle registration number MZ01 P2457 and MZ01 J8843 to the MVI registering on 9/7/2021, which was after a lapse of about 90 days when the alleged accident was happened. And para number 7, Your Lordship, when
Yes, after a lapse of- Okay.
para number 7, Your Lordship, when the MVI personnel had conducted accident inspection, the alleged accident vehicle were already removed from the place of occurrence. And under para number 8, Your Lordship,
Yes.
para number 8,
I do not know.
I do not know whether the MVI personnel had visited the PO or not. And para number 10, Your Lordship, I paid the total amount mentioned in bill dated 7/7/2021, that is the final bill, as alleged by the claimant, to the Highland Chevrolet on 7/7/2021. Again, as per the evidence of the CW number 2, Your Lordship, the evidence of the CW number 2 is at page number 74. Page 74, George H.S. Thoite. Your Lordship, the relevant portion is para number 3 of cross-examination. Cross-examination by OP2. Para number 3, may you read, Your Lordship?
Claimant witness 2. Para
Para number 3.
number 3. By OP2, page 77.
Yes, Your Lordship. Your Lordship, para number 3. It is a fact that the total estimated bill amounting to rupees 280,482 was paid by the claimant, Sila Sangzula, which was received by me, since the said vehicle MZ01 J8843 was finished the repairing works.
Total estimated amount of maintenance is paid.
And para number 7, Your Lordship, the next page. The vehicle MZ01J8843 was delivered to the owner, Silal Sangzuela, on 7/7/2021. So, in this regard, Your Lordship, per usual of the above, it can clearly be seen that the requisition for inspection of the vehicle were made only after the repairing works were done and after the vehicle was delivered by the workshop to the claimant. Hence, the findings of the MVI, as reflected in the MVI report, cannot be accepted as damage suffered by the vehicle due to the accident of 10/4/2021. Even presuming that an accident took place on 10/4/21, Your Lordship, however, there is no document to show that any damage was caused to the vehicle belonging to the claimant due to the said accident, and as such, the contention of the claimant in the instant case regarding damage caused to his vehicle cannot be accepted. Because when the MVI inspected the vehicle, all the repairing works had
Had already been
already
completed.
been done, and the vehicle was delivered to the alleged owner. That is my first point, Your Lordship. And the second one is regarding vehicle at fault, Your Lordship.
Yes.
As per the State Police report, Your Lordship, which is at page 21, the second paragraph, Your Lordship, page 21. From part 2, spot inquiry revealed that the cause of accident is due to rush and negligence driving on the part of Scorpio, number such and such, driver Lal Nun Chunga, son of Lal Sianga of Longklai, Pierre Ramlun Vengthar Aizol, who drove the vehicle in a wrong side position and over speeding. Parachi, this has reference to CLSU PS GDE number 150 at around 2:30 p.m. dated 10/4/2021. Here, the police report has stated that spot inquiry revealed that the cause of accident is due to rash and negligent driving. And the said report has reference to CLSU PS GDE. In this regard, the police, it may be stated that the police who prepared the police report in his evidence, that is, cross-examination by counsel of OP number 1 under para number 2, the cross-examination of
Page.
police report is at page 79. Evidence is at page 79.
CW3.
SI Rom Fang Zawa, Your Lordship, 79, 80, 79, 80, 81. Page 81, Your Lordship.
His cross,
Para number 2.
page 81.
Yes, Your Lordship. Under para number 2,
81, yes.
that police has stated that I was not present when the accident was happened at the spot. That means he was not present at the spot. And under para number 9, Your Lordship, that police has stated that under para number 9, at the request of the parties, no further investigation was conducted since both the parties had made an agreement between them and no criminal case as per the provision of IPC and MV Act 1988 was registered against the driver of Scorpio MZ01P 2457. In this regard, I would like to read the evidence adduced by the OP number 1, Your Lordship. The evidence of the OP number 1 is at page 45.
Contents of.
The cross-examination portion, Your Lordship. I think it's in under page 52, the cross-examination, para number 18.
Page 52.
Para number 18.
No, page 52 is proposed issues.
The last portion of the cross-examination, Your Lordship. The cross-examination is up to para number 19,
No, page.
page
Because
40,
here, page 52,
45, 46, 47, 48, 49, 50, 51, 52. 52,
52.
as per my paging. The evidence adduced by
Here in my copy, page 52 is proposed issues in MACT case number such and such. How is yours?
Your Lordship, the OP number 1 evidence is which starts at page 45.
OP1 cross, na?
14.
You're talking about OP1 cross. OP1 cross is page 55.
55.
Yes.
So cross-examination.
It is a fact that the vehicle of OP1 such and such was validly insured, that one, and also the driver of the said vehicle possessed a valid driving license.
The evidence of La
Crossed by
Ramchena.
OP1. Crossed by OP2.
No, Your Lordship, he was not cross-examined by OP number 1. The evidence of 45, no, page 45, evidence
45.
45. It starts from page 45.
Page 45 is.
The evidence of La Ramchena.
No. It is a letter written to the presiding officer, MACT. The pages are not telling. Page 50. Examination in chief of OP1 is at page 45.
Oh, 45.
Yes.
And
Examination in chief of OP1. You're referring to that?
yes, Your Lordship.
Examination in chief of OP1, Shri
45.
Lal Ramchena. Yes.
This is
Tell me the para, relevant para.
58. Lordship, 49, 50, 51, 52. Lordship, page 53. Page 53, para 18.
Lal Ramchena. Para
Para 18,
18.
yes.
We do not have any agreement
Yes,
with
Your
this one.
Lordship. Yes. In contrary to the evidence adduced by the police, this witness has adduced. This is the owner of the Bolero car.
This is page 73 in my copy.
Oh. So he deposed that, Your Lordship. We do not have any agreement.
So
Bet-
this is cross of
Council
cross by OP2.
2.
OP2 para 18.
Yes, Your Lordship. Though the police, in his police report, has stated that there is
There is
an
an
agreement
agreement,
between the parties, but the owner of one of the vehicle has stated that there is no agreement between them, and no document was exhibited. Your Lordship, in this regard, in the instant case, the inquiry officer was not examined.
Inquiry officer not examined.
Yes, Your Lordship. An inquiry report nor FIR submitted in the instant case. And no independent witness was examined. And above all, Your Lordship, no regular case was registered against the driver of the Scorpio or any of the accident vehicle. So the facts and circumstances stated above would indicate that the alleged accident was not due to the sole responsibility of any of the drivers of the vehicles. In fact, if any of the driver was responsible in causing the accident, the same needs to be proved with reliable evidence. So, if that is the case, it is the duty of the claimant to prove those facts by producing reliable evidence, witnesses. Further, it may be stated that the claim was filed by the claimant under Section 166 of the MV Act, which requires proof of negligence. In the instant case, there is no reliable evidence to show the accident took place on 10/4/2021 due to the sole responsibility on the part of the driver of the Scorpio, and that severe damage was caused to the vehicle belonging to the claimant. In this regard, I would like to submit some citation, Your Lordship.
Yes. Yes.
Your Lordship, first I would like to submit the decision made by this High Court, Ifal bench, in RK, Madhu, Rajit, and another.
2002-1 GLR.
Yes, Your Lordship. The relevant portion is at para number 12. Para number 12.
Yes.
May I read, Your Lordship?
Yes.
In the suit, it was is the plaintiff who sought for a degree declaring the plaintiff as the owner of the suit land and the plaintiff number 1 as its sebite, and further a degree that they have the absolute right of possession and enjoyment of the suit land, undisturbed by the defendants and their previous agents, apart from a decree for perpetual injunction and a decree for damages, etc. The plaintiff's claim title over the suit land on the basis of the factum that the suit land is recorded in the name of Sri Mahaprabhu, plaintiff number 2, installed and worshipped by the late Brahma Mai alias Nambi Maharani of Janmasthami, Imphal, and that she decided the suit land to the deity for its Seva Puja. Your Lordship, this sentence. It was the plaintiff who came to the court for a decree as to its legal rights, depending on existence of facts, which he asserted in the pleadings. The plaintiff, therefore, was required to prove about the existence of all those facts for a decree. So in this case, it has clearly been stated that it is the duty of the plaintiff to prove his case. And another one, para number 15, Your Lordship. Regarding burden of proof, Your Lordship.
Para 15.
Para 15.
Yes.
I'll read from on whom the burden of proof lies. Your Lordship, on whom the burden of proof lies can be ascertained by taking note of the fact as to which the parties will succeed if no evidence is adduced or given on the either side. The burden rests on the party who would fail if no evidence at all is adduced. The burden of establishing the case rests upon the party who essentially asserts positively the issue raised. This burden remains unchanged and never shifts under any all circumstances, as clearly indicated in Section 101 of the Act 1872. The aforesaid rule pertains to the burden of proof as a matter of law and pleading. The other aspect of the burden of proof is the burden of adducing evidence. The burden of proof in this respect may shift throughout the trial. The distinction between the burden of proof as a matter of law and pleading to that of adducing evidence is a matter of prime importance. As alluded above, the plaintiffs came for declaration of their title, and therefore it was for the plaintiff to establish their title affirmatively. So, from the observation of this Your Lordship, it is the duty of the plaintiff or the claimant to prove their case. And the next one is Oriental Insurance Company. Here, I would like to read para number 24, Your Lordship,
24.
page 659. The bottom portion, Your Lordship, starting from therefore. Therefore, the victim of an accident or his dependents have an option either to proceed under Section 166 of the Act or under Section 163A of the Act. Once they approach the tribunal under Section 166 of the Act, they have necessarily to take upon themselves the burden of establishing the negligence of the driver or owner of the vehicle concerned. But if they proceed under Section 163A of the Act, the compensation will be awarded in terms of the schedule without calling upon the victim or his dependents to establish any negligence or default on the part of the owner of the vehicle or the driver of the vehicle. So in this case, the claim has been filed under Section 166. So it is the duty, the claimant has duty to prove his case. Another one, Your Lordship. The decision made by this court in Lal Parmoy versus C. Lal Thang Buana. Para number 16, Your Lordship. May I read, Your Lordship?
Yes.
Para number 16. Reliance has been placed on the case of Matthew Alexander Subra by the Learned Counsel for the appellants to contend that negligence can be proved even on the basis of preponderance of probabilities and not on the basis of proof beyond reasonable doubt. The said decision is in respect of the standard of proof to be applied by the tribunal, considering a petition for compensation for death or injury in a road accident. The fact, however, remains that the alleged negligence on the part of the driver of the vehicle has to be proved. And if proof of negligence is not discernible, the tribunal will have the liberty to consider and dispose of the claim petition under the given facts and circumstances of the case. In the present case, although there is no denial on the part of the rival parties that the deceased had expired because of spilling of bitumen on his body and he having sustained grievous injury, but the fact remained that there is no investigation report apart from the lone police report prepared by an inspector who otherwise was not posted in the concerned police station at the relevant time, and that he had based the investigation report, which again was not exhibited or produced during the claim proceedings. In the instant case also that were not exhibited or produced. So the standard of proof, Your Lordship, the standard of proof may be, I'm continuing, Your Lordship,
Preponderance.
Yeah.
Yeah, it may be preponderance, but
of
then,
probabilities.
but then they have to prove the negligence.
Yes.
That's what you want to say.
That whole paragraph is relevant in this case, Your Lordship.
Yes.
And again, my other submission, Your Lordship,
1 minute.
regarding ownership of the vehicle.
This is MEC Appeal 3 of. This other case citation is not there. This Oriental Insurance Company.
Oriental.
Mm.
Oriental
Only
Insurance.
the party's name is given.
Only para number 24.
No, I mean citation.
Citation.
Oh, is this 2007 for SCR?
Yes, 2007 for SCR.
This is MSC 3 of 22. Okay.
Lordship, another point, my ground,
Then-
my other ground, regarding ownership of the vehicle. The claimant has stated that he does not enclose a registration certificate of the vehicle and that he is not the registered owner of the said vehicle. Your Lordship, in this case, the registration certificate of the damaged vehicle was not enclosed. But
RC was not enclosed.
yes, RC was not enclosed. The claimant has alleged that there was a sale deed. That sale deed was annexed as Annexure 5 in the claim petition, which is at page 17.
Sale deed, yes, page 17, annexure 5.
There is a sale deed. It's in the Mizo vernacular, Lordship.
Yes.
Yeah, that talks about the vehicle was sold by Arlan Monpuyi, residents of Chaltlang, Aizawl, Mizoram, on 5/3/2015 to Pulal Sangzula, son of Ramluna, residents of Kohai, Mizoram, for a sum of rupees 3 lakhs. And it was signed by Lal Sangzula, who is the claimant herein, the respondent herein, and Arlan Monpuyi, the alleged owner. In this regard, Lordship, I would like to submit that there is no proof that the alleged seller of the vehicle, that is Arlan Monpuyi, was the rightful owner of the vehicle. So if there is no proof that that person is the rightful owner, then the alleged sale deed cannot be accepted. Moreover, there is no witness to the alleged sale deed, and the same was not registered as per law. In fact, in the instant case, no evidence was led by the claimant. No evidence was led by the claimant throughout the whole proceedings of the trial in order to prove that the vehicle was purchased by him from the rightful owner. So, in this regard, hence there is no proof that the vehicle actually belongs to the claimant.
No evidence was also led.
No evidence
regarding
was led,
the ownership,
apart from that sale deed.
apart from this sale deed.
Yes. So So, since there is no proof that the claimant was the rightful owner of that vehicle, then the claim ought to be dismissed. Regarding a workshop bill, Your Worship, I would like to read out the ground number 5 of my appeal memorandum, which is at page number 9 of the appeal memorandum.
Your
Page-
grounds,
Yes,
page,
9, Your Lordship.
yes.
Ground number 5. For the Delaney may I read, Your Lordship? For the Delaney Tribunal had erred in law and in fact in awarding rupees 2,80,482 along with interest at the rate of 7% per annum to the claimant due to the damage suffered by his vehicle, that is Chevrolet Spark. There is no proper foundation to declare that the claimant oblique respondent number 1 had actually spent the said amount for the repairing course of his vehicle due to the said accident. In fact, no final bill was produced in connection with the instant case. Even the claimant himself has deposed in his examination in chief that the bill annexed by him in the claim petition is not a final bill. In fact, no final bill was produced in connection with the instant case. Again, the workshop bill paid by the claimant cannot be decided on the basis of the evidence adduced by George S. Thoite, service manager of Highland Chevrolet, as his evidence has suffered from some defect. In this regard, it may be pointed out that while the claimant himself has stated in his evidence under para number 9, para number 2 of cross-examination by OP number 2, he stated that he is not the registered owner of the vehicle. On the other hand, George S. Thoite has stated under para number 1 of his cross-examination by OP number 2 that he had seen the registration certificate of the vehicle bearing registration number MZ01J8843 and that the registered owner is Lal Sangzula. So that evidence, both the evidence were contradictory to each other. So since that evidence has shown the character of the manager of that Highland service manager, then his evidence cannot be admitted to the appellant. Moreover, as pointed above, Your Lordship, there is no proof that any damage was suffered by the said vehicle due to the accident 10/4/21. Hence, even presuming but not admitting the fact that the claimant had paid a sum of rupees more than 2 lakhs towards the repairing cost of his vehicle. However, there is no proof that the same was due to the accident, which took place on 10/4/2021. Your Lordship, in the instant case, there is non-joinder and misjoinder of necessary parties. The claim was filed only against the owner and the insurer of the Scorpio, but the insurer, the driver, both the driver of the accident vehicles were not included. Yes. So, in view of the above, Your Lordship, my humble prayer before this honorable court is that to dismiss, to set aside the judgment and order passed by the Delaney Tribunal in MSCT case number 24 of 2021.
19/10/23.
Yes, 19/10/2023. Thank you, Lordship.
Yes. One and two respondents. Who's appearing for respondent 1? You.
Respondent number 1, my lord.
Yes.
My lord, with regards to Section 166 MV Act, negligence was already proved in the trial court by the SI Ram Fangzawa, officer in charge, Selsu Police Station. As he was already stated that the accident was caused by the sole negligence of the Scorpio driver. Scorpio bearing registration number MZ01P 2457, driven by Lam Nun Chunga, son of Lal Sianga, resident of Long Klai. Permanent address Ram Lun Veng Thar Aizol. Then,
But he said that he was not there, no, at the accident.
yes, my lord. With regards to the damage, the damage caused by our vehicle, the damage was clearly caused by that accident, because this was already proved in the trial court that George Toite, the service manager, had accepted all the bills paid by the claimant. Then, my lord, with regards to the grounds, the grounds submitted by my learned friend, the appellant. With regards to grounds number 1, the appellant is liable to pay the claim amount 280,482 along with 7% per annum from the date of filing, that is 17/8/2021, to the claimant, who is the respondent number 1. With regards to the grounds 2, about sale deed, the claimant is the claimant is not the registered owner at the time of the accident, but sale deed was annexed along with the claim petition in the trial court. But the respondent was not mutated the name of the ownership at the time of the accident. This does not the annexure of the sale deed clarifies that the claimant or the respondent number 1 is the real owner of the accident vehicle, which clearly highlighted.
So you're saying that it was already bought, but the name was not mutated in the records,
Yes, my lord.
in the RC.
May your lordship, in the May your lordship, can I furnish a copy of sale deed about ownership?
Yes.
That Kariko Kri versus Nune Tayang and another. May your lordship, John, page number 2.
Page 2.
Yes, my lord. In health, that can I see that
Yes.
highlighter?
Yes, yes,
Yes.
yes. The High
In-
Court overlooked this one.
Yes, in the Naveen Kumar versus Vijay Kumar in another's case, like the last part. Yeah.
Mere failure to get registered. This one.
My lord, can I read it out?
Yes, please read.
Yes, from the beginning, like Naveen Kumar, from the line of Naveen Kumar versus Vijay Kumar in another's was rendered in the context of and for the purposes of the Act of 1988 and not for general application. The judgment itself made it clear that despite the sale or transfer of the vehicle in question, a claimant or claimants should not be made to run from pillar to post to find out who was the owner of the vehicle as the date of the accident. If the sale or transfer was not carried out in their books by the authorities concerned by registering the name of the subsequent owner, be it for whatever reason, further vehicles being goods, their sale would be covered by the provisions of the Sale of Goods Act 1930. And the same make it clear that the conveyance of ownership of the vehicle would stand concluded upon execution of the document of sale or transfer, and registration of the new owner by the authorities concerned would be a post-sale event. Mere failure to get registered the name of the new owner of an already registered vehicle does not mean that the sale or gift transaction would stand invalidate in as such a vehicle. In this judgment, it is too clear that if the sale deed was executed before the accident or anything happened between that.
But can you say that your sale deed was legally executed? Was it registered?
It was made between the layman, and so it may be acceptable in the purview of law because it was executed between the laymen. Yes. Then so in our case, we can say that the claimant is the owner of the vehicle.
Okay,
May Your
then
Lordship,
the other case?
May Your Lordship seen Naveen Kumar versus Vijay Kumarin and others. In this case also, may Your Lordship turn page 14, para 13, the last part,
Wait.
the second last.
Para 13.
Page number
Oh, okay,
14,
yes.
okay.
The submission of the petitioner.
Yes, yes, my lord. In this case, the submission of the petitioner is that a failure to intimate the transfer will only result in a fine under section 53, but will not invalidate the transfer of the vehicle. In Dr. T.V. Jones, this court observed that there can be transfer of title by payment of consider and delivery of the car. In the last part, the owner within the meaning of section 2, subsection 30 is liable to compensate. The mandate of law must be fulfilled. May the Lordship turn page 5.
In the same judgment.
Yes, yes, my lord. Page 5, para 6. This is the definition of the owner. The expression owner is defined in section 230 of the Act 1988. Thus, owner means the person in whose name a motor vehicle stands registered, and where such person is a minor, the guardian of such minor, in relation to a motor vehicle which is the subject of a hire purchase agreement, or an agreement of lease or an agreement of hypothecation, the person in the possession of the vehicle under an agreement. So, based upon this definition, we can say that in our case, in the instant case, the claimant can be termed as the owner of the vehicle. So now we are liable to, we are entitled to
Compensation.
receive compensation from the appellant. So with regards to the grounds made by my learned friend, the appellant, about para 3.
Their grounds, para 3.
Yeah. Yes, yes, my lord.
Yes.
We are highly objected that his presentation that because the Ram Fangzawa SI had already adduced in his evidence that the accident was solely caused by the Scorpion driver. So the Scorpio had also obtained a valid insurance under the appellant insurance company. So we can say that insurance company is liable to pay the claim amount to the respondent number 1. With regards to their contention grounds for we can say that the accident was caused, the accident was happened, and our vehicle was severely damaged, and it was also repaired in the Highland Chevrolet workshop. Then it was also proved by, and it was also repaired by us, and we have already paid the claim amount to the service manager of the workshop, and service manager had also deposed evidence in the trial court that our vehicle was severely damaged, and it was also repaired in their workshop. So there is no doubt at that point. So our vehicle was severely damaged, and workshop bill had already paid by the claimant. So that is a reliable document which we can produce in the trial court. About the DTO reply, the DTO report and all, that it was
The
made
NVI
by
report,
yeah.
the dates.
Yes, my lord. The NVI had made formally about that matters. We have no knowledge about that. So this can also prove that our vehicle was severely damaged at that accident. So the applicant is clearly liable at that point also. Then about their grounds petition in point number 5. The service manager, George Thoite, had already received the claiming bill about the workshop bill from the claimant, and it is just a name share like estimated bill, like we have made a proposed bill, and after that proposed bill was already paid by the claimant, which is the respondent number 1 in this instant appeal, and which was received with service manager seal. In the claim petition also, we have already submitted all the bills which was paid by the claims petition. So it is true clearly that the claimant had already paid the repair bill to the service manager to the Highland Chevrolet workshop. Then about the ownership, the registered owner of the vehicle, MC01 J8843. About the sale deed, we can say that the claimant is the true owner of the accident vehicle. About their grounds.
What about the non-joinder?
Non-joinder.
The drivers were not impleted.
The driver is not an unnecessary party in the motor accidental claim trial. In the motor accidental case, like we have already implemented the owner of MZ01 P2457 Scorpion and the insurance company. Then about their grounds, their appeal grounds, point number 6. We can say that the claimant Chevrolet Spark is only had only filed the claim petition in the trial court, not that one. Scorpion owner. So we can
So
say that
insurance was not necessary
yes,
for you.
yes, my lord. Then about point number 8, we can say that all insurance policy is liable to pay the claim amount 280,482 at the rate of 7% per annum to the respondent number 1, because insurance policy was valid at the time of the accident.
Insurance for the Scorpio.
Yes, my lord.
Okay. Anything else?
Can your lordship,
Yes.
can I furnish a copy of insurance company liable to pay the claim? In the Supreme Court case, Civil Appeal number 1544 of 2024, Bajaj Alliance General Insurance Company Limited versus Mukul Agarwal and others. May your lordship turn page 24. Paragraph 42, point number C. The insurer shall pay a sum of Rupees 374,012 to the owner with simple interest, thereon at the rate of 6% per annum from the date of filing of the complaint before
No,
the
if
state.
negligence is proof, that is, there's no doubt, no dispute about that. Insurer has to
Okay,
pay.
my lord. This case law is just prove the liability, payment
No,
of liability.
regarding liability, there's no doubt.
Okay, my lord. Then my humble submission for today is that to pay the claim amount to
The judgment
respondent
should
number
be
1.
upheld.
No.
1910-23. Okay,
Okay, my lord, thank you.
yes. Then R2.
May it please Your Honor,
Yes.
I will be presenting my arguments on the, in correspondence with the grounds of appeal on the memorandum of appeal. So please, may I take Your Honor to page number 6, grounds of appeal. 6 of memorandum of appeal.
Yes.
So the first ground is very vague and there's not much to comment. And regarding the second ground, regarding the ownership, regarding the ownership of the motor vehicle in question,
Yes.
Your Honor, according to the MVX section 157, there has been a deemed, if there has been a transfer of the ownership of the motor vehicle, and there has been a deemed transfership there.
Section 157.
157, yes, Your Honor. And at the third ground of appeal, not the sole negligence of the driver. The ground was that it is not the sole negligence of the driver and no regular case was registered. And Ram Fangzawa was not present at the spot when the accident took place and no independent witness examined to identify the cause of accident. Actually, Your Honor, FIR or any registered case is not a necessity in filing accident claim case. It is not necessity, it is not mandatory. And from the evidence and record, it has been proved that the accident had been occurred due to the sole negligence of the offending driver. That can be seen from the police report and the other reports. And as already said, the matter of proof in accident claim is not beyond reasonable doubt, but it's to the preponderance of probabilities. And moreover, Motor Vehicle Act is a welfare legislation, and it seems that the appellant required some proof to beyond reasonable doubt.
Do you have any ruling on this, that FIR is not necessary in accident claims?
No, Your Honor, there is no mentioning in the Act itself.
Okay. Then, okay, welfare legislation. Yes.
And so, grounds number 4. No reliable document to show that the vehicle actually suffered severe damage due to accidents. Reports were done after the vehicle had been repaired. That was their grounds. Your Honor, all receipts and the payments of the bill, of the workshop charges, they have been produced at the tribunal and were also exhibited without any objections. And also that the issuing workshop manager of those receipts.
So these bills were not disputed
Not
before the
disputed,
trial court?
were all exhibited without any objections. And they were also, again, proved by the issuing workshop manager, that Toiba. So, as already mentioned, the standard of proof to be applied here is preponderance of probabilities. And it is our opinion that that proof is enough to prove the negligence or to prove that such damages had been caused to the motor vehicle. Your Honor, regarding the grounds number 5, the grounds is that there is no proper foundation to declare that the claimant had actually spent the amount for the repairing cost of his vehicle, and no final bill was produced. Workshop bill paid by the claimant cannot be decided on the basis of George Toiba, as his evidence suffers from defects, as he said that he had seen the motor registration and that the claimant is the registered owner. That was the grounds. Your Honor, here, as already mentioned, all receipts and payments are exhibited, produced before the tribunal and exhibited without any objections, and also had been proved by the workshop manager, George Toiba himself. And regarding the discrepancies, the contradictions of evidences given by George Toiba was regarding the ownership, the registered name of the motor vehicle. But that is not an issue here because, as we already mentioned before, that according to Section 157, due to that sale deed,
Deemed ownership.
yeah, there was a deem. And one thing I forgot to mention is that unlike immovable properties, motor vehicle sales, transfer of motor vehicles is governed by the Sales of Goods Act. And on grounds number 6, the claimant is not a prudent man, as no insurance policy was produced, no proper evidence to show that the accident took place due to the negligence of the defendant. Your Honor, as already mentioned, the modes of proof was preponderance, and according to the evidence of the claimant, all the evidence corroborate to each other. The reports given, the receipts of payments, and the witnesses.
What about driving license and all? They were produced before the trial court.
Yes, it has been produced.
Valid driving license.
It is valid, Your Honor, yeah. And moreover, it has not been reasoned here at the grounds of evidence, so we're not going to that one. And the claimant is not, yeah, Your Honor, so all this evidence of the claimant were corroborated and they had proved negligence on the part of the driver. And regarding the non-joinder and of necessary parties at ground number 7,
7.
non-joinder of necessary parties, and as already mentioned, the driver is not a necessary party, and also the insurer. Regarding the insurer of the other motor car, the other vehicle, yeah.
Yes.
Your Honor, the instant appellant is always at liberty to file an application under Section 170 for the implement of the insurer, or any other applications for the implement of any other party whom it thinks is a necessary party. So non-joinder, raising the question of non-joinder at a later stage at this appeal is not very proper right now. And regarding the agreement between the respondent number 1 and number 2, which earlier mentioned by the Land
Yes.
Council, yeah, you know, that was not from the, that was out of their memorandum of appeal, so I don't think it's necessary to discuss further. So, Your Honor, please humbly praise that this court may upheld the judgment.
Okay.
Your Lordship, if I may
Yes.
allow. I don't know why
Yeah,
my...
one thing is that you
Yeah.
have to, put it within the appeal memo. You
Yes.
cannot go beyond what you have stated in the appeal memo. Anyway,
Your
yes.
Lordship, I don't know why my learned friend has made submission like that, because that submission was against the interest of his client, the respondent number 2. The respondent number 2 is the owner of the Bolero.
Scorpio.
Yes, Your Lordship.
Scorpio or Bolero? Scorpio.
Scorpio, yes, Your Lordship. So, if we see the written statement of the owner of the Scorpio, the respondent number 2, the written statement is at page number 34 of the LCR.
Yes. Where do you want to refer? Page 34.
Yes, Your Lordship. Para number 4, Your Lordship. Objection on merit, Your Lordship. Para. May I read, Your Lordship?
Yes.
And that in regard to para number 8 to 10, on this day, 10/4/2021, at 1 p.m., the answering OP received information that the accident occurred where a vehicle involved on the accident is owned by him, bearing registration number such and such, which was driven by his driver, Lal Chung Nunga, age 20, son of Lal Sianga, late, residence Long Tlai. Present address Ramthun Vengthar, Aizawl, Mizoram, from Aizawl to Thenzawl. The other vehicle involved on the accident is a Chevrolet Spark, bearing registration number such and such, driven by the claimant Lal Ming Duoma, age 41, son of Arwal Kum of Kohai, on his way to Aizawl from Kohai. The collision of the above-mentioned vehicles took place at Chalkon, Saila, Mizoram, where the OP number 1's driver does not have any fault on the occurrence of the accident. So, I don't know why my learned friend has made submission against the interest of his client. And if we see the evidence adduced by the OP number 1, the evidence of the OP number 1 is at page 45.
P1, yes.
Oh, OP number 1. May I read para number 2, Your Lordship, of the examination in chief? that on 10/4/2021 at 1 p.m. I had received an information that the accident occurred where my vehicle, Scorpio, bearing registration number such and such, involved on the accident, which was driven by my driver Lal Chung Nunga, son of Lal Sianga, residence, present address, Ramthun Vengthar, Aizawl, Mizoram, from Aizawl to Thenzawl, was collided with the claimant's vehicle, bearing registration number such and such, which was driven by the claimant's driver Lal Ming Duoma. The collision of the above-mentioned vehicles took place at Chalkon, Saila, Mizoram, where my driver does not have any fault on the occurrence of the accident. Your Lordship, in this regard, what I would like to point out is that no question was raised against this contention. Your Lordship, if we see the cross-examination part, cross-examination by counsel, claimant's counsel, the cross-examination part is only one page. May I read the Lordship?
Yes. P1. Okay.
Cross by claimant's counsel. Para number 1. I have not known the claimant Silal Sanzila and I have known him from the accident. Para number 2. It is a fact that at the time of the accident dated 10/4/21, my driver Lal Chung Nunga had a valid driving license. 3. At the time of the accident, my vehicle bearing registration number such and such had a valid insurance policy, and my insurance policy is not is number such and such under United Insurance Company Limited. Para 4, I have denied that I am liable to pay the claim amount of rupees such and such. 5, I am not deposing falsely today. So no question was even raised to rebut the allegation made by the OP number 1 in his examination in chief, which means his contention that his driver does not commit any fault in causing the accident was not even rebutted or even questioned by the opposite party. So in this regard, the claimants were expected to make at least some question, but no question was put to against that submission. Lordship, another point regarding bill. I would like to emphasize what I have already submitted, because though that huge amount of money may be paid by the claimant, that is beyond our knowledge. But even though, however, there is no proof that the same was due to the accident, which took place on 10/4/2021. There is no proof, because the MVI report, the police report, those things were not dependable due to the facts stated above, because the MVI inspection was done after all the workshop works were already done, and
after the repair was completed,
yes,
you're
after
trying to say?
yes, after the repair was completed. So I don't know why, I don't know how the MVI could come to the conclusion mentioned in the MVI report, unless there is another accident after the vehicle was delivered or released to the claimant. Even if that is the case, the appellant has no connection in that accident. And regarding sale, Your Lordship, the fact, the question in this case is, since no RC was enclosed, no RC was enclosed, who is the register? There is no proof. We are not. We have no knowledge who is the registered owner as per the RC. If the RC is there.
But you contested the case, isn't it?
Yes.
You contested the case.
Yes.
Was this issue raised before the tribunal?
Yes. Yes.
What did the tribunal say on this tribunal's finding on the ownership? What did the tribunal find? Where is the judgment? Whether the claim application is maintainable, whether it is maintainable.
Your Lordship, no specific decision was made in this regard as per the judgment. But my humble submission is that until and unless the seller's right over the vehicle is proved, then the seller cannot legally sell the vehicle. Until and unless the right of the seller over the vehicle was proved, the alleged seller have no right to sell the vehicle.
That's all.
That's all, Your Lordship. Thank you, Your Lordship.
Heard, yeah, please write. Heard learned counsel for the appellant. Shri, your name?
K. Laldin, Your Lordship.
K. Laldin Diana. And learned counsel MS Vanlal, this one, no? Vanlal for R1 and Mr.
Samuel Lalramruata.
Lalian Puya for Samuel for R2. Judgment is reserved.
Deeply honored.